There is no fiancé. There is no wedding date. There is, as of this moment, no man in Princess Leonor's life that Spanish media has confirmed as anything close to a future husband. So when we talk today about the prenuptial agreement for Princess Leonor of Spain, we are talking about a document that does not exist yet, built entirely from precedent, from Spanish law, and from the one real example the Spanish royal family has ever produced. That example belongs to her own parents, and it is one of the strangest, most tightly guarded contracts in the modern history of the Spanish crown. Understanding it is the only way to understand what almost certainly waits for Leonor. Let's start with the basic legal concept, because Spain treats this very differently than most people expect. In Spanish law, a prenuptial agreement is called capitulations matrimoniales, and it is not the slightly taboo, faintly unromantic paperwork it's often treated as in English-speaking countries. It's a formal contract, executed before a notary in a public deed, that determines the economic regime governing a marriage. Without one, Spanish couples in most regions default into what's called Sociedad de Ganancias, a community property system where most income and assets earned during the marriage are considered jointly owned. Capitulations allow a couple to opt out of that default and choose something else entirely, most commonly separation de bienes, a total separation of property where each spouse keeps what is legally theirs, before, during, and after the marriage, with no automatic claim on the other's wealth. For an ordinary Spanish couple, this is a fairly dry piece of estate planning, usually 2 or 3 pages, often drafted only when one partner has significant family wealth or a business to protect. For the family that occupies the Spanish throne, it becomes something else entirely, and we know this because of one marriage in particular, the wedding of King Felipe VI, then Prince of Asturias, to Letizia Ortiz Roquesolano in May of 2004. Before that wedding took place at the Almudena Cathedral in Madrid, Letizia was required to sign a set of capitulations matrimoniales, and what leaked out about that document over the following 2 decades paints a portrait of just how seriously the institution treats these arrangements. According to her own cousin, David Roquesolano, a lawyer who reviewed the document on her behalf and later published a controversial memoir about the experience, the contract he was handed ran to somewhere between 40 and 50 pages, prepared by Uría and Menéndez, one of the most prestigious law firms in Spain, a firm that has long served the royal household. For context, Roquesolano has said a typical Spanish prenuptial agreement runs 2 or 3 pages. What Letizia was asked to sign was, by his account, roughly 20 times that length. We should be honest about where this information comes from, because it matters. Much of what's known about the specific contents of that document traces back to Roquesolano's book, a source the royal household has never confirmed or denied, and to second-hand reporting built on top of it. Some of it is plausible legal structure. Some of it reads more like tabloid embellishment. But the broad strokes have been repeated consistently enough, across enough independent Spanish outlets, that a general shape has emerged, and it's worth walking through, because it tells us so much about how the institution thinks. The marriage itself was registered under separation de bienes, the separate property regime, which by itself isn't surprising. What made the document unusual was everything layered on top of that basic choice. According to Roquesolano's account, the contract specified that in the event of divorce, the Crown would guarantee Letizia's economic well-being for life regardless of the separate property arrangement, providing a generous allowance along with the use of 2 residences, one for regular use and one for summer, each staffed. In other words, even under a legal regime designed to keep the couple's finances apart, the institution built in a permanent, contractually guaranteed safety net for the outgoing spouse, a kind of state-managed soft landing rather than a clean legal break. The document reportedly went further into territory most prenuptial agreements never touch at all, specifying what would happen to custody of any children born to the marriage. According to multiple Spanish outlets drawing on the same underlying account, the agreement stipulated that in the event of divorce, custody of the couple's children would go to Felipe, not shared, not negotiated later in family court the way custody disputes normally proceed in Spain, but pre-decided, years before either daughter was even born. If accurate, that's an extraordinary clause, because it strips away one of the most contested and emotionally significant elements of any divorce and settles it in advance, purely to protect the institutional interest in keeping the heirs to the throne under the direct guardianship of the reigning line rather than a former spouse who would, after divorce, have no constitutional role at all. And then there's the detail that tells you everything about how these negotiations actually happened. Roque Solano has recounted that during the tense meeting where the terms were finalized, Felipe called in briefly and delivered a blunt message: the capitulations were non-negotiable, not one comma could be changed. Whether or not every detail of that account is accurate, the underlying dynamic it describes rings true to how constitutional monarchies generally handle this problem. The person marrying into the institution is not really negotiating with their future spouse as an individual. They're negotiating with a legal team representing the crown itself, an institution with its own interests, its own continuity to protect, and its own centuries of precedent about how outsiders get absorbed into the family without ever gaining a claim on its assets or its authority. Now here's where we get to the genuinely interesting question, the one that makes Leonor's future situation structurally different from her mother's. Letizia married into the family as the future consort, a role that, as we've discussed before, carries no constitutional function under Article 58 of the Spanish Constitution. Her capitulations, whatever their real contents, were fundamentally about protecting the crown's institutional assets and the line of succession from a spouse who held no formal power to begin with. Leonor's situation runs in the opposite direction. She is not the person marrying into the throne. She is the throne. Whoever she marries will be the outsider, the person without constitutional function, the person whose only formal protection under law is Article 58's guarantee that he cannot assume any constitutional role. That means any future capitulations Leonor signs would likely be constructed to protect not a consort's position within an existing dynasty, but the reigning monarch's personal and institutional assets from a spouse who, by law, has no claim to the crown's authority regardless of what happens in the marriage. This distinction changes what such a contract would probably need to cover. Where Letizia's agreement reportedly focused on guaranteeing her a soft landing despite having no institutional power, a contract for Leonor would likely need to address something almost nobody discusses when they talk about royal prenups: the fact that any children she has will themselves be in the line of succession to the Spanish throne, regardless of what happens to her marriage. A custody dispute involving a future king or queen's children isn't just a private family matter under Spanish family law. It's a question with constitutional weight, because whoever raises those children shapes the person who will eventually inherit the crown. If Leonor's own parents felt it necessary to settle custody in advance specifically because keeping the heirs under royal guardianship mattered more than ordinary custody norms, that same logic would apply even more forcefully to Leonor's own children, since they would stand even closer to the throne than she once did as her father's daughter. There's also the matter of privacy, and this is worth clarifying because it's one of the most misunderstood parts of this entire topic. Spain has, in recent years, pushed toward greater transparency about royal finances. In 2015, the royal household published Felipe's personal assets for the first time in Spanish history, a modest sum of savings, art, and jewelry, released explicitly as a gesture of transparency and accountability to the public. But an asset declaration is not the same thing as a marital contract. Capitulations matrimonials are private legal instruments, filed with a notary, and Spanish law provides no mechanism requiring the crown to disclose their contents to the public, transparency push or not. Everything we know about Felipe and Letizia's agreement came out sideways, through a family member's memoir and years of second-hand reporting, not through any official channel. Whatever agreement Leonor eventually signs, if she signs one at all, will almost certainly remain just as sealed, a private notarial document that the public will only ever glimpse through leaks, memoirs, or divorce proceedings, if any of those things ever happen. Before we close, it's worth addressing something directly, because it's been swirling through Spanish tabloids recently and it deserves a clear-eyed correction. There has been recent speculation in some Spanish outlets suggesting Felipe and Letizia's marriage is heading toward a formal separation, built partly on unconfirmed claims about the couple living increasingly separate lives. None of this has been confirmed by the royal household, and Spanish tabloid reporting on the royal marriage has a long history of running well ahead of verified fact. We mention it only because it's the same media ecosystem that will inevitably generate speculation about whatever agreement Leonor eventually signs, and it's worth remembering, right now, before that speculation even begins, that unconfirmed tabloid claims and verified institutional fact are two very different things, even when they appear side by side in the same article. So where does that leave us? There is no prenuptial agreement for Princess Leonor of Spain today, because there is no wedding to prepare one for. But if the pattern set by her own parents holds, and there is every reason to think it will, whoever she eventually marries will sit down, at some point before the ceremony, with a document running dozens of pages longer than anything an ordinary Spanish couple would ever sign, drafted by a top-tier law firm on behalf of an institution far older than either person at the table, addressing not just property and money but the future custody of children who will be born already standing in line for a throne. It will be sealed, private, and almost certainly non-negotiable in the ways that matter most. And the only reason we know any of this is because, 20 years ago, one reluctant bride's cousin decided the country deserved to know what marrying into the Spanish crown actually costs.